And today, in fact, I got one message, very interesting message from Ken Kitonga from Kenya. He's a practicing lawyer there. He has been participating at this talk for from very first day, and he had very nice words to say about our talk. Uh, so thank you, everybody. Uh, Today, our talk is uh, about, we will start with pleadings in arbitration. Uh, One thing which came to my mind was that generally what I have seen here in India particularly, uh, Ajay says it's very informative session. Uh, Generally what happens, people who wants to learn arbitration or practice arbitration or who are practicing arbitration, they think that knowing arbitration and conciliation act is everything, and if you know the provisions of arbitration and conciliation act, uh, you gain mastery over the subject. Please appreciate that arbitration and conciliation act only gives a legal framework, and it only talks about very broadly about arbitration. It does not go into the details of the procedures and processes which are fundamental to the whole process, like how to write pleadings and nuances of pleadings, how to do cross examination, what is cross examination, how witness statements are to be prepared, what is the relevance of this, how deliberation happens amongst the arbitrators, so how awards are to be written. So all of this you don't find mention in arbitration and conciliation act. Now so today we will talk about pleadings in arbitration. uh, Before we talk about pleadings in arbitration, I'll give you one uh, interesting tip, uh, which can be a tactical tool for all of you in arbitration. And that is, try to become claimant in an arbitration proceeding. The moment disputes have arisen, try to be claimant. This gives lots of advantages. It has got inbuilt advantages. Claimants in civil law jurisdiction particularly are in driving seat. They get first and last chance of hearing in terms of written pleadings or in oral submissions. In fact, very general perception amongst arbitrators, particularly in India, is that claimants are the real aggrieved of the situation, and counterclaims are generally counterblasts. So you should try to be applicant, claimant, claimant in arbitration. That is one tip I thought I must share with all of you. Now, when we talk about pleadings, what happens in India, the claimant files its written submission, and here it is called statement of claim, because this is the expression you find mentioned in your Arbitration and Conciliation Act. In court, we call this plaint. Here we call it statement of claim. And the respondent, the other side, files its statement of defense. In short, we call it SOD. So Written statement, which is defense filed in court of law, is called written statement. Here we call statement of defense. The uh, respondent can also file its counterclaim along with the written statement of defense or thereafter. Uh, Not always, but invariably, claimant is given one opportunity to file its response to the statement of defense, and that is called uh, rejoinder. In very few cases, when in rejoinder new facts are brought in by the claimant and new documents are adduced, then respondent is also given an opportunity in the form of sur rejoinder. But generally, it is a statement of claim, a statement of defense, and rejoinder. What are the different nomenclatures which are used globally for a statement of claim? That is also very important for all of us to know, because when you see literature, foreign literatures, when you see different rules, uh, it is always better to have clarity about the nomenclatures. So obviously, a statement of claim is one expression. Statement of case is another nomenclature. Memorial is yet another nomenclature. Points of claim, in fact, exit call memorial. Points of claim is yet another nomenclature for a statement of claim. There are places where people call this brief. So I'll summarize different nomenclatures given to statement of claim. I once again repeat myself. Statement of claim, statement of case, memorial, points of claim, and brief. And the defense of the respondent again has different nomenclatures. Uh, so different nomenclatures for defense are statement of defense, a statement of reply, counter memorial, points of defense. These are some of the typical nomenclatures you may come across about the defense. I'll repeat myself because some of you may want to write this. A statement of defense, statement of reply, counter memorial, and points of defense. And response to defense, which we typically call in India as rejoinder, is generally in international arbitration world is called replique. Replique, REPLIQUE, or reply, or reply brief, or replication, typically called, which is the expression used in India. And there are occasions where reply to reply is also filed, like here we call this sur rejoinder. Different nomenclatures given to this are rejoinder, duplique, 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 counter rejoinder, second rejoinder, rebuttal. Somebody had asked a question about rebuttal. Rebuttal, sur rejoinder, are the expressions which are generally used herein with regard to the pleadings everywhere. Uncitral calls it written statements, like your defense in court, written statements. In fact, Uncitral calls both pleadings as well as a statement of defense as written statements. It's not only limited to written statement in a sense that it is the defense only. No. So whether it is your statement of claim or a statement of defense, Uncitral refers this to as written statement. And as I said, ICSID calls it this memorial and counter memorial. Now, another important thing which we need to be aware of, how many pleadings are allowed in international arbitration and domestic arbitration. In domestic arbitration, as I said, in India, it is a statement of claim, a statement of defense, and rejoinder. So basically, in common law countries, it is not only the case in India, nomenclature may be different. In common law countries, two pleadings are for the claimant and one is for the respondent. So as I said in the beginning, try to be the claimant that helps you. So you get two opportunities to come out with your written brief, and one is for respondent. However, in civil law system and civil law jurisdiction, both sides get two pleadings each. And even in international arbitration, I have had occasions where, and in fact, chairman was a common law from common law jurisdiction, though one of the arbitrators was from civil law jurisdiction for another ICC arbitration. So in the procedural order number 1 itself, chairman was very clear that both sides will be given equal opportunity in terms of pleadings as well. See, this is very typical of common law, that there is a belief that, and there is a practice that the claimant or the plaintiff gets the last right of audience. So that is the trend, that is the practice in common law countries. But in civil law, it is both sides are given equal opportunity. And in international arbitration also, increasingly, both sides are being given equal opportunity. So two pleadings for each of the parties. So that is another thing, important thing. Now, let us talk about a structure of pleading. Then we will go into other aspects of pleading. So how pleadings are to be structured. So as I said in my talk of first day, if I am not wrong, that you must know the form in which, or a structure in which you have to do your written advocacy. So first page is the cover page, which gives description of the tribunal. It describes the institution under which arbitration is happening. If it is ad hoc arbitration, then it writes the name of the tribunal members. Cover page also writes the name and description, gives this name and description of the parties. And in the middle, you should write what is this pleading. If it is a statement of claim, then write a statement of claim. If it is a statement of defense, then write a statement of defense. You should write the date somewhere at the bottom, and at the bottom of the page, name of the advocate. So first page, if anybody looks at, have a look at the first page, he gets to know what is this pleading all about. So that is very important. Now, on the next page at the top, first thing you have to write is introduction. And in introduction, you write about parties, you write about the arbitration agreement, the contract. Thereafter, you have a different head that can be termed as background to the dispute. So in the background to the dispute, you will give the background of the whole dispute, that there was a contract, it was being done in a particular manner, and thereafter it was broken by the other side, how it was broken by the other side, and how you are before the arbitration tribunal. And thereafter, you will have another head of factual basis of the claim, in which you basically give the summary of the cause of action and what are the factual reasons because of which the claims have arisen. Then you have legal basis of the claim. Arunav asked, do we have a structure in the Indian Act? Yes, section 23 of Arbitration and Conciliation Act talks about this. It says, oh, you should write this. So I can read this for you. It says, within the period of time granted, agreed upon by the parties or determined by the tribunal, the claimant shall state the facts supporting his claim, the points at issue, and the relief or remedy sought. And the respondent shall state his defense in respect of these particulars unless the parties agreed otherwise. So basically, this is the format which everybody talks about. And after you, and thereafter comes the request for relief, and then comes reservation of rights. Reservation of right is very important thing which I see most of lawyers in India tend to forget or are not aware of. Reservation of right is a very important thing where you reserve your rights for certain things, that reserve your right to file additional pleadings, reserve your rights to file additional legal authorities, reserve your right to file additional documents. Or if you have other reservations, sometimes you reserve your right to for other similar things. So this is something very important. And after this, we have appendix to the statement of claim. So claimant's list of exhibits, list of legal authorities, claimant's chronology of events if you want to give, which helps the tribunal, which helps everybody. Now next subtopic for pleading would be how to write. So I would say, first of all, there has to be some exercise by the lawyers, and the lawyer who is going to prepare the brief, he himself must, not through some colleague, he should himself prepare one chronology of events. In that process, what happens is you understand the whole case. You understand all the documents, what all are written in all the documents. Mastery of evidence, that is mastery of documents primarily in commercial arbitration, is very, very important. Therefore, chronology of event, the moment you get the file, start preparing chronology of event and keep updating that chronology of event for yourself as and when you have subsequent pleadings coming, as and when new documents are coming, as and when any subsequent developments keep happening, or there is documents getting discovered during production of documents discovery, or at later stage some documents are filed. So if you prepare chronology of event, your task becomes so easy, and you will have flow of the entire event before you in the form of your chronology of event. So you must give due importance to preparation of chronology of event. What you write in chronology of event: first column serial number, second column date, third column the description of the document. So this is how you write them. And when you refer to document, you should also refer what is this document about. Suppose it was written by party A to party B, what did party A said in that? So use the same expressions which were used in the letter, so that it is not your narration, but it is the document, basically exactly the document, so that you are never having any confusion about the nature of the document. So this is very important thing, and that's why I'm giving a lot of emphasis on this. Now, after this, you have to do something called preparation of case theory. Case theory is the most fundamental aspect of written advocacy. What is case theory? Case theory is theory of your whole case. What is your case all about? If I ask you to write your entire case, for which documents are running into thousands of pages, and if I ask you to write your whole case in one paragraph, not a paragraph running in 1 page or 2 pages, not more than one fourth of the page. If you can write your case in 1/4 of the paragraph and show it to anybody who has nothing to do with the case, and if you can understand your case fully by reading that one paragraph, who are you, who was your contract with, what that person did, what injury was caused to you, and what remedy is available to you in the contract or in equity or under common law or in law, and why you are right. So if you can write one paragraph which can convey the entire case of yours to anybody, any judge, any arbitrator, it means you have succeeded in having a case theory. That means that your fundamental case, the main issue involved in the case, should get covered in that 1/4 of your page in one paragraph. Let me give you one analogy. Anybody who has observed Supreme Court proceedings on the days of special leave petition would know that Supreme Court of India decides SLPs generally, not all SLP, generally in a minute. So what happens? Lawyer stands up before the court. In less than a minute or in a minute, he tells the whole case. to the judge in few sentences. And judge tells you back, if judge is not agreeing with you, in 1 or 2 sentences, judge will tell you, no, this is not your case is this. So therefore, you should not get the relief. So in 1 or 2, 3 sentences, that mastery, if you are training yourself from beginning of your career or at any stage of your career, it is all about being aware of this aspect of case theory. So if you are aware of the importance of case theory, half the battle is won. Now, for preparation of case theory, you have another analogy. Assume that judge is before you, and if anybody wants to write, because I got a question which says, can you repeat it? If you want to write, write. Assume for preparation of case theory, how you have to do it. Assume that the arbitrator, presiding arbitrator, or the whole tribunal is before you, and tribunal is asking you 3 things. 1, what are the real issues in your case? What are the real issues in your case? So that is one question posed to yourself from the side of the tribunal. 2, what are your answers to them? So what are the real issues in your case? What are your answers to them? And 3rd question judge will pose to you is, tell us, how are you right? What are your answers? Then how are you right? So what are the real issues involved in the case? What are your answers to that? If you practice this, think about these 3 sentences, ponder over, just repeat in your mind and do mental exercise for these 3 sentences during your morning walk. Somebody says, is case theory and case brief are the same? Not at all. Case brief is whole pleading. So if you do this mental exercise while doing your morning walk, first put these 2 questions and then fit these 3 questions to any case which you want to prepare and argue, and see how it is going to help everybody. This is very, very important. Now, next aspect we move on to is that a good pleader or a good draftsman is a good storyteller. You should be a good storyteller. You have to bind the tribunal. You have to create interest in the tribunal about your case. That art you have to develop. And how you do that? First thing we have to keep in mind is, we have not to irritate the judge. In fact, it is said that written pleading is your personality of the author, the lawyer. If you have written well, judge will come to the first page and see, or arbitrator, oh, who has written this? Nicely written. And if you have written badly, again, he'll remember you that you are an irritating person. So never be irritating person. Be a good storyteller. How you do that? First thing, write simple English. Pleading is not a test of your vocabulary. That doesn't mean that you have to not write nice words and nicely. You have to write nicely. but it should be plain English so that everybody can read and understand it. Now, and it should not be very legalist. In fact, you should avoid, see, generally what you see in pleadings, particularly in India, is that every paragraph starts with the expression that, so and so, that so and so, that so and so. First of all, get rid of this. Another very common phenomena is that people write every sentence, or in the middle of the sentence, they'll say, it is there, it is stated that, it is respectfully stated that, it is submitted that. Baba, you are submitting what you are writing. So no need to say, no need to remind the judge you are submitting here again. Secondly, notwithstanding anything contained anywhere and all, those kind of expression avoid. So what you do? You should develop the art of writing in talkative English, as if you are talking to the judge in person, pleasantly, with an idea to persuade the judge to agree with you. As a good storyteller. Now, another very irritating thing is you come across big paragraphs. Now, I have seen paragraphs running into 1 page, 2 pages, 1.5 pages. So once that person, you must know the audience. You must know the audience. It should not happen that till the time your audience reaches the middle of the page, middle of the paragraph, he forgets what you had written in the beginning of the paragraph. It should never happen like this. So it should be small, very small paragraphs. It should be concise. Lengthy pleadings are not good pleadings. I'm reminded of an incident. In fact, it was written somewhere that one of the biggest American lawyers had once written a letter to one of his friends. It was a lengthy letter running into many pages. At the end of the letter, he said that, hey buddy, I have not been able to write a smaller letter because I didn't have enough time. That means writing a smaller write-ups, pleadings, letters, memorials requires better understanding of what you are writing. It requires more hard work. So one should Sumit says that clients will have a feeling that lawyer has worked harder. Client may have a feeling that lawyer has worked harder, but the judges will have a feeling that you are not worth being an advocate. That's the problem. And you are not there to please your client, you are there to please the arbitrator and the judge. Now, so your drafting should be concise, it should be clear, it should not be cluttered. Description of the parties in the very first paragraph. Suppose name of a company is XYZ private limited company so and so, another is ABCD private limited company, another so. Give a short form, first name of the company, and address, refer to them with the first name. No issues. So, and sometimes we come across footnotes. Footnotes, to the extent it is not very lengthy, is acceptable. But if it sometimes you see half page is only footnote, then it is irritating. So one should be conscious of that. Now, it should be concise, clear, and logical. Now, one may ask, how do you become logical? Logic comes from, I am giving you a tip. Logic comes from a structure with subtitles. This is the art you have to develop. Quality of your drafting depends on the structure of your pleading, drafting, and have heads and subheads. So it's all about like preparing a good table of content. Go to any good author of books, or go to any publishing house, editor of a publishing house. He will tell you the good table of content is the hallmark of good authorship. So prepare a good table of content that gives you good structure to your drafting, and that art we have to develop. Now, paragraphs should be numbered. Typeset should be pleasing, not irritating. Font size should be appropriate, 10 to 12, as I said yesterday. Arbitration spacing be kept at 1.5 unless your arbitrator says have it to. Hyperlinking is useful. There should be clear referencing to exhibits and paragraph number of that particular exhibit. It should be pleasing to the eyes of the arbitrator. Now, in one arbitration in which I am the presiding arbitrator, one statement of defense came where of the statement of defense, no, sorry, along with the statement of defense, there was counterclaim. So what has been done is, after every counterclaim, all supporting documents are filed. And thereafter comes another counterclaim, another head of counterclaim, again supporting documents. Now, I would say we should, this is not the right way of writing things. In fact, I suggested the learned counsel to make it in the way it should be done. So we should be careful with all of this. And as I said other day, I am telling you once again, your draft year law student. That is the test. Now, this was some few things about counterclaim. Now, and the whole pleading. Now, let us start the journey of the arbitration. Journey had started with writing of drafting of arbitration agreement, appointment of the arbitrator, right arbitrator with expertise, right arbitrator with knowledge, expertise of the domain. So appointment happened, tribunal got constituted, preliminary meeting happened, procedural order number 1 was passed, parties completed their pleadings, exchanged their pleadings, documents, exhibits were also exchanged. Now, what happens thereafter? What happens thereafter, typically, Indian setup is, but before I go to that stage, let me talk about, in brief, about discovery. In fact, I talked about day before yesterday, if I'm not mistaken. Discovery is an important process. I said it is the costliest process in which one party, see, don't believe that I can rely upon only the documents which I have in my power and possession. Even if documents are with the other side, you can request for those documents. If documents are with third parties, you can get those documents summoned through the court, process of the court only. Obviously, you have to take permission from the arbitration tribunal. So this process is very, very important. So after pleadings are exchanged, you have this process of discovery. In fact, under CPC, Civil Procedure Code of India, also you have three categories of discoveries which are envisaged. One is discovery by way of production of documents, which I just talked about. Then you have discovery by way of inspection. So document come and you can go and have inspection of the documents. Third is discovery by way of interrogatories. So interrogatories are basically questionnaires which are prepared by one side before trial commences and given to the other side for their answer, and same can be done by the other side. So in discovery is an important process. You can narrow down the controversy to larger extent by way of this process. So this is very important, and in international arbitration particularly, this is extensively used. The most notorious discovery process is of USA. UK has taken a middle path. India, we generally do not use it. It is very seldom used. Civil law culture in countries, they do not like discoveries. They believe that you should win or lose on the basis of your evidence which you have in your power and possession. So they dislike discovery. But limited discovery, so far as arbitration is concerned, and as I said, in arbitration for evidentiary processes, if one has to understand, one must refer to IBA guidelines on taking of evidence. And there it talks about discovery. It talks about experts, party appointed experts, tribunal appointed experts, and all of that. So discovery is a very important process through which you can get in possession of, and it is not only about being aware of the discovery. If you master this process of discovery, you can really stump the other side. Now, it depends on how much you know about the facts of the case. It depends on how much you know about the industry practices. Now, in a very recent arbitration against a European company, I was representing the employer, and what I had said was, I had asked and requested the other side in the discovery to produce the tender breakup now. Tender breakup, I said. What is tender breakup? Somebody asked in under which provision discovery is mentioned in the act. Forget about section. See, my whole endeavor in this course is, let us know, assume that Arbitration and Conciliation Act gives answer to everything as I said, it is only a legal framework which talks about very, very basic and fundamental things. These are universally accepted processes. Your civil procedure code has writes about this in great detail. Order 11, Order 12, Section 30 of CPC. Read them. You'll get to know better. Now, in that case, I asked for tender breakdown. Why I asked for tender breakdown? Because the contractor, this contract was suspended during the execution of the work, and finally it was terminated. So the contractor was asking for loss of profit at a particular rate. I said, see, you should know the industry practice. I know every contractor, once he gives its bid for any particular project, prepares a tender breakup, how much cost he is going to incur for production material, how much cost it is going to incur for the overheads on its people, how much profit it is going to have from this. Now, that was a big problem for the other side. They could not say they do not prepare it. I said disclose it. Now, if in your tender breakup you wrote that my loss, the profit I am expecting from this project is 5%, and here you are asking 15%, then you are finished. You can only ask for the profit which you have lost. So you cannot ask for, I asked for, now they had claim for escalation. So I said, give me the native software which was used for all of this. I asked native software for various other purposes. I asked the correspondences from the site to the head office. Now, what does it mean? If you know the industry, if you know how that industry works, then you will have better ability and information to prepare your discovery. And with good discovery, you can really get in possession of lots of important documents. Obviously, discovery request has to be for reasonable document, for relevant document. It should be reasonable, yes. Now, so arbitration commenced, pleadings were exchanged, documents were exchanged, discovery is over. Now, there is a process typically in India, which is basically replica of Indian courts procedures, and that is admission and denial of documents. That means even in your Commercial Courts Act, there's a detailed procedure prescribed for that. Now, what is admission denial? Let us assume that 100 documents are written, filed by the claimant against the respondent, 100 is filed by the respondent against the claimant. Out of 100 documents, 95 documents may be such which respondent will say, yes, I received these documents or I wrote these documents. There may be very few documents, one or two, which they may say that I never wrote or I never received, or this is a forged document. Same is with the case of the other side. So with regard to those few documents, 1, 2, 3, 4, one will deny those documents, rest all documents are admitted. So this process is called admission and denial. You prepare a list, say this document I admit or this document I deny. Now, the international best practices go slightly different. Under that process, what happens is I had talked about this earlier also, that all documents filed by the parties are deemed to have been admitted by the other side, unless any specific objection is raised with respect to a particular document. So this whole process can be dispensed with. And if anybody says, no, this document I did not write or I did not receive, he will bring this to the notice of the tribunal. That's it. And that document which is being disputed and denied, if respondent disputes a particular document of the claimant, then claimant will have to prove this document during trial. Trial is examination in chief, that is the filing of evidence by affidavit or witness statement, which is the expression used in international arbitration, which will be tested through cross-examination. So only those documents are required to be proved, because documents which are admitted, facts which are admitted, are not required to be proved. Now that is very important aspect which we can use here in India as well. That's a good practice. Another thing is framing of issues or points of determination. What are the points you hold your questions today? Again, we will have 5-10 minutes to answer those questions. You write down on your notebooks, and after we finish the talk, we will take all the questions. Framing of issues, or it is called determination of points for determination, is another aspect which is commonly used. There are tribunals which says we are not going to frame issues or have points of determination. We will treat all the claims and counterclaims as the issues. This is not a very good idea. If one wants to have control over the proceeding, it is better to have points of determinations or the issues framed. But framing of issues should be a serious exercise, only then it helps the cause and purpose. Otherwise, it is neither here nor there. Now, if you want to have analogy under order 14 of CPC. Now, though it will take 2-3 minutes, but since we have a lot of law students and non-lawyers also, may I give a very basic example how issues can be framed and what are issues, and then we will move ahead. Let us assume that party A agreed to sell his house to party B. Party B lives in Mumbai, party A lives in Delhi. So agreement to sell. If you want to sell a property, what you write is called agreement to sell, a purchase or agreement to sell. So agreement to sell was executed between the parties in Delhi, in the house of the party A. And after 3 months, money was to be paid and property was to be transferred to the party B, and registration was to be done. What happens is, when party B came to Delhi to meet that party A refused to execute the sale date. And this is how party A goes to court in Delhi, and the lawyer of the party writes a statement of plaint which he files in the suit or in arbitration, whatever you, this is just an example. And see the pleading. Pleading says party A on such and such date, 1st January 2019, started from his house from Mumbai, took a cab, Ola, went to airport. Airport, he took Indigo, and from there he landed at Delhi. Delhi airport, he took Uber. Reached the golf link at the house of party A. There at the gate, what he found was there was a watchman and there was a dog. Dog was Lebra. He went inside. Party A was wearing a jacket red, and what was offered to him was a coffee. Thereafter, agreement was executed. Then he repeats same entire event on the date when party B had visited the party A's house, when party A had refused to execute the sale deed. Again, he says this time he took Air India, this time he took private taxi, this time he took this and all of this. Now, this pleading was given to other side lawyer, and other side lawyer says you are wrong. The party B had not taken Ola from his residence, he had taken Uber. He had not taken Indigo, he had taken a SpiceJet. He had not taken this private taxi here, he had taken something else. At my gate, watchman was not of the description he gave, he is shorter than that. Dog which I have is not Lebra, it is Boxer. My client was not wearing red jacket, he was wearing green jacket. What was offered to him was tea, not coffee. Now, going by the CPC provisions, it says disputed questions of fact give rise to framing of issues. If you take it literally, then all the facts are disputed here. So issues will be framed. So, are you saying that court will say which flight A took to meet B? Which watchman was, what was the description of the watchman? Which color of dog was this? Which color of jacket he wore? No. Court will frame only two issues. Whether parties enter into an agreement or not. If A says I had entered into agreement, then even that is not an issue. A says I was ready to give him the property, transfer him the property. B was not ready to buy the property. That is the only controversy. If that is the only controversy, then only issue which is required to be framed is whether B was ready and willing to purchase, or whether A was ready and willing to, whether B was ready and willing to purchase the property or not. And everything else written in those thick submissions are of no use. That is called framing of issues. So this was for a younger law students and the younger lawyers, just as a brief. Now, so framing of issues should be done, and if you know your case theory, then framing of issues also becomes very, very simple. Now, what we have done is drafting of agreement, constitution of the tribunal, appointment of the tribunal, constitution of the tribunal, exchange of pleadings, exchange of documents, the discovery, admission, denial, framing of issues. Now we go to the stage of trial. If we call it trial, we call it trial. And what happens in trial essentially is, earlier in India, we used to call this examination in chief. in which both sides used to bring their witnesses. They used to narrate whatever facts, their account, whatever facts they wanted to depose before the court, testify before the court. Now, give me 1 second. बाद में करो. So earlier it was called examination in chief. So witnesses will come, they will give their account about what they saw, what they sensed, what they did, and this testimony was called examination in chief, and this used to be tested through cross examination. Now in the CPC and in many jurisdictions, including under UK in their CPR, civil procedure rules they call it, now what we file is evidence by way of affidavit, or sometimes people call it affidavit by way of evidence, whatever nomenclature you give. So in court proceedings also, now you have a process which is in substitution of earlier concept of examination in chief, and it is called evidence by way of affidavit. So whatever that witness had to depose in the witness box before the tribunal or before the court, same thing is done in writing on affidavit. So this is called evidence by affidavit. And in international arbitration world, it is called witness statement. And now witness statement is another, after your main pleading, a statement of claim or a statement of defense. This is the most important document which you have to be conscious about. Akash has written a question. I'm going to answer this. Don't worry. What does it contain? A question of Akash was whether witness statement contains the same thing which is written in the SOC or the SOD. And Akash is not wrong. This is what typically is done in India. Most of the evidence by affidavit you come across are nothing but mere reproduction of a statement of claim and a statement of defense. Only change you find is, instead of starting the sentence with that, this happened, which people use generally that, here people write in first person, I, and then they repeat the same thing. So it is no different than statement of claim and defense, which is really the wrong way of writing written statement or evidence by affidavit. One should know the purpose of evidence by affidavit. When you filed your claim and till now, lot has changed, lot has developed, lots of things have been admitted and even denied. If you have document to support that and that document has not been disputed, again, why to bother yourself to write all of this, which is admitted, which is supported by evidence, which is not denied? So basically, yes, to complete the narration, you should give some facts, narration of facts. But purpose of affidavit is that the witness It is not an exercise to be carried out completely by the lawyers. Lawyers have limited role to play in the preparation of witness statement and evidence by affidavit. What lawyer is supposed to do is more like a director for a movie. Actor is the witness. So director will say what is the format of witness statement or evidence by affidavit. This generally is the format. How should you write, the writing pattern you can say, where you can give emphasis which is relevant for the case, where you can just write summarily, where are the gaps in the evidence available on record for which oral evidence is needed and to which that witness was a party. Let us assume a situation that there was a meeting between the parties in which something was agreed by the respondent, and today respondent is denying this fact in the arbitration, and there is no document in support of that particular meeting. In other words, that meeting was not minuted, there is no minutes of meeting. Now what will happen? Only way you can prove what transpired in the meeting is by way of calling a person who was present in the meeting. So he'll come and say that I was present in the meeting, and then he will be cross-examined. So this is the purpose. If you have gap in evidence, there is no documentary evidence, and you are party to that, then you are a competent witness to depose. Another thing is, suppose you wrote a letter, you delivered a letter personally, and that is being disputed by the other side. You will say, yes, I was the person, I gave it, I did this, I did this. Sumit Kansal is writing many things. Sumit, you hold back. Keep it with yourself. We will discuss it after today's talk, maybe in the last 5-10 minutes or thereafter. It is distracting me. Now, so what is the purpose of evidence by affidavit? The witness statement. It is essentially, purpose is to prove something which cannot be proved by documentary evidence. Or let us assume a situation where a meeting was minuted, but the way it was minuted, it does not reflect the correct understanding and the discussion amongst the parties. One can have witnesses to say what transpired was this, not what is written. So this is how we have to understand the purpose of witness statement. What lawyers should do is, lawyers should sit with the particular witness, hear from him what he knows about that particular instance or instances, take note of that, request the witness to, suppose witness relies upon, he says that there was a document, ask him to get you those documents. In fact, you can ask the witness to come up with his own writing the way he understands the whole thing, give it to you, and thereafter you can, based on that, put this in a proper form and give a proper structure. Because he is not a lawyer, he would not know how to write things and how to address. But as a lawyer, you are not supposed to twist the facts. We have to be aware of ethical values which are needed, and otherwise also it is said that Never ever ask your witness as a lawyer, never ask your witness to tell lies. Ask him to be honest in his deposition during the cross examination. And if that is the case, it helps you immensely. Otherwise, if he tells lies, you tutor him to do that. Ultimately, you have opposite side lawyer who is ready to cross examine you, who is ready to confront your witness with documents. He can impeach your witness. Tribunal can ask 10 questions, 20 questions, and everything will fall flat. So you will damage your case. Somebody asked me what to tell the witness, what should we tell him for the cross examination. First thing, tell him to be polite. Second thing, explain him about the layout of the arbitration tribunal, because most of the witnesses are first timers. Make him comfortable, because they get, sometimes they are nervous, they are very excited, they're full of anxiety about facing the tribunal, facing the cross examination, which they have never done. They are under tremendous pressure because of the hierarchy in their departments and all of this. So you have to make them comfortable, and that comes with your composure, with your confidence. Where from you get confidence as a lawyer? You get confidence with the mastery of facts and laws and mastery of the documents. If you as a lawyer know the entire case thoroughly, you are confident. That gets across to the witness. He will become confident. Tell him, which I do. I remember I was once sitting with one witness who was to depose in London in a ICC arbitration. And that person was in fact having difficulty in speaking Hindi or English properly. He was very nervous. It was very high stake case. I told him only one thing. You give me your few days, and one thing I can assure you, that after you will return from this hearing from London, you will come out to be much better a professional. It will be an amazing learning process. And last thing I told him, that it will be most enjoyable process of your life, because you know your facts, you are telling truth, so you can demolish everybody's any attempt to demolish you. And this is exactly what happened. This man was so confident there. So you need to take the witness in this particular fashion. Now, what is the time? 6:48. Oh my God. Only 10 minutes. Now, one more thing which we need to understand is that there are two categories of witnesses. One is fact witness, in other words, witnesses of fact, and another category is expert witnesses. And we will close today's session with this about the expert witness, and then I'll take few questions. So fact witnesses are the witnesses who are aware of the facts of the case and who are going to depose on facts of the case. And expert witnesses are people who are expert in a particular field, and he is going to give his opinion to the tribunal. So that is why it is called expert opinion. very loose example, but relevant example can be, you can say that like handwriting experts, you have provision for that in CPC or Evidence Act also. So they are relevant witnesses, they are testimony, handwriting experts. But this is very simplified way of looking at it. Typically, in big disputes, you will have multiple experts. You may have experts on law. Lots of our Supreme Court judges, in fact, there was a famous case which was a LCIA arbitration, if I'm not wrong, where two Supreme Court judges were cited. Both sides had cited retired Supreme Court judge because, and now you may wonder, how can you have expert on law being cited? See, in any arbitration, which is international arbitration, if dispute issue is with regard to foreign law, quote unquote foreign law, then foreign law is a question of fact, it is not a question of law. And on foreign law, you will have to cite experts. So there, law applicable was English law and foreign law was Indian law, because there were certain transactions in India and question was whether that transaction in India was in accordance with laws of India. So on that, parties had cited experts. And both honorable Supreme Court judges gave opposing opinions. And now that is again expert opinion. Typically, in construction arbitration, you invariably have delay experts who does delay analysis, disruption experts who does disruption analysis, quantum experts who does quantum analysis. In fact, in one of my arbitration, ongoing arbitration, big 5,700 crore around dispute. Now I have an expert from Singapore who is deposing, who is preparing, giving report on delay and quantum both. Though you have very few can give you his expert opinion on delay and quantum both. You may have joint venture disputes. Lots of experts are needed. Merger acquisitions arbitrations, lot of them, lot of people are needed, experts are needed. Once in one arbitration seated in Singapore under SIAC rules, I had cited one professor from IIT. So recently in one arbitration, I had cited one foreign expert on quantum. So this is again very interesting thing. And experts will prepare their own report, because generally these experts, invariably, they are expert evidence is admissible in arbitration proceeding. Yes, Sujata. In fact, section 26 of Arbitration and Conciliation Act talks about the experts, appointment of experts by tribunal. It is not very expressly talking about experts appointed by the parties, which is in fact should have been the case, but it is routinely done. And experts are very important stakeholders, and please mind it, they are very costly, guys, no less than lawyers. They charge in crores, good experts. So that is a very interesting thing, expert report. So I think it is 6:54. I should stop myself here and I'll take questions now. So anybody having any questions, we'll take questions. If documents are misplaced by the other party deliberately before the process of discovery, then Om Purohit. see, appreciate doing these adventurism costs the party. If tribunal will get to know that you are playing with the tribunal, you are concealing the documents, you are destroying the documents, tribunal will draw something called quote unquote adverse inference. And that goes heavily against you. Now somebody says, Rajesh, whether certified copies are required. In arbitration, no original, no certified copy, nothing is required until unless somebody challenges the original authenticity of a document. Only in that circumstance you are supposed to prove it. If there is any question of law arising, then what the tribunal will? Tribunal will decide the question of law. Tribunal is supposed to decide facts and law both. Is tribunal a fact-finding authority along with deciding interpretation of law? Yes. Does evidence by affidavit contains so and so? That I have already answered. ICC rules, my God, keeps changing very frequently. ICC rules for taking evidence has a benchmark for taking of evidence, how much it is binding. See, ICC rule will only apply to ICC arbitration. So far as IBA rules of taking of evidence is concerned, this is a benchmark for international arbitration. 60% cases people use it. But again, for your arbitration, a particular arbitration, it will be binding only when parties agreed to be bound by that, not otherwise. Yes. Could you explain the reservation of right? That I have already explained. You reserve some of your rights. Just as an abundant caution, I'll file my document, additional pleading. That's it. Other party is bound to provide documents in discovery or may refuse it. Is other party bound? They are bound to produce if they are in power and possession of the documents. They cannot say, I'll refuse it. If you refuse it, tribunal will pass adverse inference against you. Tribunal may sanction you with cost at the time of awarding cost. If the Sujata says, if the witness is hostile, then how to deal with? See, this is not a criminal trial. Here, hostility, this is unheard of. In civil proceedings, that too in arbitration, see, you cite a witness only when you are confident about his role. And if somebody becomes hostile, you have to live with it. Then you say that he has turned hostile, and then you cross-examine him. Similarly, suppose a third-party witness comes and same thing happens, he turns hostile, then you cross-examine him. Put questions in a way that you prove him wrong. Can award be given according to agreed settled terms? Yes. Can you share with us the draft of a procedural order? How can I share this? I don't know. If I'll talk to the organizer, if it is possible, that will be circulated. Sir, one document cover various issues, out of which some are correct and some are not. How to deal at the time of admission and denial? See, this, though your Commercial Courts Act says that content admitted and the receipt admitted, contents denial is an accepted norm because it became a trend in India. Otherwise, we are only concerned with authenticity of the document, whether document exists or not. So far as the genuineness, so far as the veracity of the content is concerned, that is for the parties to prove, and that is the part the parties to agree, argue. Yes. Understanding the whole process, is arbitrator a full-time activity? What is that? Or litigation can be done by a young lawyer? Sumit, understanding the whole process, is arbitrator a full-time activity? See, Sumit, it is an interesting question. It is not necessary that you should start your full-time career as arbitrator, because in initial years you don't get assignments quickly. It takes some time. You need to mature. You need to have some experience. So you do arbitration cases, you do litigation, go to courts. See, going to court and doing trial is not a sin. It helps you. Only thing is you should be aware of how to wear these two hats. So like I do, I go to court and evening or whenever I am not in court, I wear a different hat. Then I forget CPC. So I wear a hat of other things and I wear guidelines and all of that. So in fact, it helps you. So no need to do that. Yes, somebody says, Akash Serawat, how do we calculate delay in quantum of loss damages while drafting SOC when expert witnesses are called only at the time of trial? See, Mr. Serawat, this is a misnomer in India that experts are to be brought only at the time of trial. In fact, client should go to the office of the experts the day he approaches for the first time his lawyer. There are two categories of lawyers. One is called pseudo experts. Another category is called testifying experts. Pseudo experts will help you in preparation of the case. SOC, SOD, help in improving your case. And testifying experts comes as an independent witness, though sometimes one gets the role of have the hat of both the roles, but sometimes in cross examination it becomes an issue. And in SOC, whatever you write, you say that it is an estimation of my claim and I'll support my claim with the expert testimony, expert opinion, expert report. So that becomes relevant. So then that will be taken into consideration. Can we get a sample draft of pleading? I'll try to circulate that. Can we restrain the process of discovery by mentioning the same in the arbitration clause to maintain the confidentiality? Yes. You can dispense with the requirement of discovery if you want by agreeing in your arbitration agreement. Thank you, sir. Very beautifully explained, Sujata. Oh, that's not the question, Sujata. If there have been no developments after filing the SOC, what should the witness statement contain similar to pleadings? See, you need to understand, Sneha, there is a different purpose which is required to be achieved through SOC and through witness statement. Your SOC is narration of whole case. Witness statement only focuses on those aspects which are in dispute, which requires to be proved. Not everything. Can the dispute be resolved on consent terms? Yes. How is award then passed? You have section 30. He says it is settlement is not incompatible with arbitration. Then in terms of settlement award will be passed, it is called consent award. Which court is empowered to set aside an award declared in international commercial arbitration? We have discussed in detail. You have to go to that court where seat of arbitration is. Thank you so much, sir. Very good and detailed explanation. Is there any other forum where arbitrators need to enroll themselves? Om Purohit. I'll talk about the accreditations aspect in my last class for all budding and potential and existing arbitrators. I'll go in some detail with that. Arbitration proceedings are dealt by normal civil courts, high courts, or not necessarily into commercial court dealt by ADs. I don't know. I don't understand the question. Thank you, sir. So these were the questions, I think. There's no other question or any other question. No, everybody said good evening. Thank you. Thank you, everybody. Thank you very much.
Thank you, everyone, for participating in today's session. I think that's it. So we'll meet tomorrow again at the same time, 5:30 p.m. on Zoom Live and on Facebook Live as well. Thank you so much.